The broadcast is now starting. All attendees are in listen-only mode.
Welcome, everybody. It is our Friday NIJC Pro Bono webinar. This webinar is on best practices for presenting Central American and Mexican asylum claims. My name is Ashley Hebner. I'm a managing attorney at NIJC. I'm here with my colleague Lisa Koop, who's an associate director of legal services here. And we're going to be talking about how you present Central American and Mexican asylum claims. A quick few logistical matters. If you have any questions, please type them into your GoTo meeting box, and we will read them out and answer them as they come in or towards the end, whatever seems to make sense. And the webinar today is being recorded, so it will be up on NIJC's website in the near future. Finally, we also wanted to note that we've done a number of other webinars on related topics. So today in our presentation, we are not going to be getting into great detail on particular social group or working with survivors of domestic violence or working with unaccompanied children, things like that. We have other webinars on our website related to those topics, and we encourage you to take a look if you'd like to do so. So really quickly on why we wanted to talk about this topic today. If you are participating in this webinar, you, like us, probably have seen in the past couple of years Central American and Mexican asylum claims taking up a significant portion of your asylum docket that you have. And so with these types of claims come a lot of complicated issues. But what we're going to be talking about today is that these cases should not be looked at or treated any differently than any other asylum case. We'll be talking a lot about that as we move forward today. All right. So really briefly about the National Immigrant Justice Center. We are an immigration nonprofit located primarily in the Chicago area with offices in Goshen, Indiana, where Lisa is located, and an office in Washington, D.C. as well. We're part of Heartland Alliance. We provide legal services to more than 10,000 immigrants each year, but a significant portion of the clients we serve are asylum seekers, and we serve most of them with our fantastic network of pro bono attorneys located here in Illinois, as well as Wisconsin and Indiana. And we really look to leverage the information we gain from our direct representation to further policy and advocacy work throughout the country. So as we get started here, we wanted to provide a really brief overview on asylum, since it's important to always go back to the basics when we're talking about these claims. So very quickly, to get asylum in the United States, you have to prove that you are a refugee, which means that you're outside of your country of nationality and you can't go back because you've either been persecuted in the past or you have a well-founded fear of persecution on account of one of these 5 protected grounds: your race, religion, nationality, membership in a particular social group, or political opinion. So this is an international definition that's been codified in U.S. law, and this is where we start from anytime we're looking at an asylum claim. And what we like to do in our claims, in any type of claim we're presenting for asylum, is to break this definition down into 5 parts. And this is much of what we're going to be focusing on today. We're going to break our presentation down into many of these different elements. So you look at the asylum definition and you pull out these 5 elements. You have to prove your well-founded fear, which is your burden of proof. You have to prove that the harm your client suffered or feared is persecution, that it was perpetrated by the government or an entity the government cannot or will not control. And then again, it has to be on account of these 5 protected grounds. One thing we're also going to emphasize quite a bit today is the importance of keeping these elements separate. The question of whether your client was persecuted is separate from the question of whether the persecution was on account of a protected ground. And whether your client belongs to a social group is a separate question from whether your client was persecuted on account of being in that social group. Often when we see bad law related to Central American cases and Mexican cases in particular, especially at the Board of Immigration Appeals level, it's because the adjudicator has conflated these elements and will say, this is not a social group because you can't show you were persecuted on account of your social group element, your social group membership. So it's really critical to keep these elements separate to help the adjudicator avoid that error. So a brief, background on why we're talking about Central American and Mexican asylum claims. Since about 2014, as we've all seen in the news, there have been record number of children, families, and adults that have been fleeing escalating violence in Central America and Mexico. And so we've been seeing this quite a bit in the news, and it's consistent with the uptick in asylum cases that we're seeing. And so we see this direct connection with the clients we're seeing and the escalating levels of violence in these countries. And so we talk a lot about push and pull factors. There are many factors that are pushing our clients out of their countries and pushing them towards to the United States, but there are also certain factors in the United States that are pulling them here instead of other countries. And so when individuals have been interviewed from Central America and Mexico as to why they have fled their country and come to the United States, we typically see that there are many different reasons that they have decided to come here. So these are just a very brief snapshot about some of the background reasons that cause many of our clients to flee. So Central America regionally has the highest femicide rate in the world. So very frequently when we're talking to girls and women from Central America and Mexico, even if they didn't ultimately flee their country because of gender violence, they've experienced some kind of gender violence in their lives, and we're going to talk a bit about that later. We've seen particularly in the Northern Triangle region as a whole, but especially in El Salvador, just really astronomical increases in violence in those countries. And recently in Mexico as well, there's been a great deal of coverage in the news recently in Mexico about how the levels of violence are really even exceeding what we used to see in the drug war, at the height of the drug war in Mexico. Extortion is a tremendous part of all of our clients' experiences. So, there was a report that stated that Salvadorans are paying as a whole about $390 million a year in extortion. So again, the extortion may not have caused your client to flee, but it was a part of their life in many cases, and something that can often shed more light on their claim. And then really speaking to the multitude of reasons that cause our clients to flee, in one survey that was done by the UNHCR, they interviewed a number of unaccompanied immigrant children, UICs, who reported that yes, 81% of them did want to reunite with family in the United States, so that's the pull factor bringing them here. But of that 81%, more than half of those children were also fleeing criminal or family violence. So these issues are all very interchanged, and it's really important to flesh out all of those various reasons and background with your clients when preparing their case. And then a few quick reminders before we move into the real substance of our presentation today. General violence is not enough to obtain asylum. And we hear a lot from our clients about the really horrific situations they had to flee and how their day-to-day existence was often just inundated with various forms of violence. And that can be useful to talk about in the claim in many different ways, but ultimately it's critical to show that your client fled because of an individualized harm. Your client's going to be specifically targeted. And there's always a risk in these cases that if you focus too much on the general conditions of violence in the country, that your adjudicator is going to start to view the claim as more of a generalized violence claim, as opposed to a claim that your client's going to be specifically targeted because of a protected characteristic. And conversely, it's really important to show to the judge that even though, or the asylum officer, that even though many people in your client's country may be targeted by gangs or by other criminal organizations, your client was being targeted for a very specific reason, which is connected to a protected ground. So it's really important to separate your client from the general conditions of violence in the country that he or she has fled from. We're going to talk specifically about particular social group today when we're talking about the protected ground, because in many cases that's the primary basis for these asylum claims. And it's really important to remember that the nuances of particular social group case law do differ quite a bit circuit to circuit. Even if you're practicing in a jurisdiction that has fully embraced the Board of Immigration Appeals definition of what it means to be a particular social group, there are still likely many nuances to the way the circuit has adapted and utilized that definition and those requirements, and then that's important to look at. So even if you have to accept that before your immigration judge or before the asylum officer, that the board's test is the test for particular social group, be aware of how your circuit's law differs, and also make sure you continue to preserve arguments against the Board of Immigration Appeals requirements. There is still litigation going on against the board's social distinction and particularity test. This continues to be a controversial and evolving area of particular social group case law. You want to preserve those arguments so that you can continue making those arguments on appeal if need be. We do have a practice advisory on our website specifically on this point, and we encourage you to take a look at that if that's useful in your case. And then remember to build your record. A lot of times when we see cases at the Court of Appeals where a gang-based claim or a gender-based claim is lost, it's often because the adjudicator finds that the record does not support Nexus, or the record does not support the existence of a particular social group. Building a record in these cases is probably more critical than in some other asylum cases that you may have. So you really need to spend significant time on this. And this doesn't just mean your client's affidavit. This means other witness statements. This means country condition evidence. This means corroborating every single element of your case. I think, bad records create bad law every day, and it's really critical you have a good record, because in these cases, more than other types of cases, there's a significant likelihood that your case is going to have to go up on appeal. Should your case go up on appeal, we definitely would encourage you to reach out to other organizations and attorneys who are regularly litigating these issues before the Court of Appeals, so you can help strategize and try to coordinate arguments with other litigation that may be going on. And with that, I'm going to turn things over to Lisa for a discussion of gang and cartel-based claims.
Sure. Hi, everybody. My name is Lisa Coop. I work with Ashley on NIJC's Asylum project. And we wanted to spend a little bit of time talking about gang and cartel-based claims as we're contemplating asylum claims arising out of Central America and Mexico. And then Ashley will talk about gender-based claims. And those really are the two most common types of asylum claims that we are seeing coming out of the region, which doesn't mean that that is exclusively the types of claims that you'll be seeing. And certainly as attorneys approaching these cases, we want to explore the viability of a political opinion-based claim or a claim based on religion. But again, going back to the building blocks of asylum and making sure that there is a nexus between the protected grounds. The protected ground is the reason the person is being harmed. Oftentimes we find ourselves arriving at the conclusion that a particular social group is the legal argument that makes the most sense in most of these cases. So that having been said, let's go to the next slide. We want to reiterate that these are viable claims. I think there's been a lot of progress in this area and further recognition among federal courts and immigration judge that claims coming out of Central America aren't wholesale not viable because they're all based on generalized violence or something like that. But there's still a long way to go in educating both practitioners and adjudicators about the fact that these really are legitimate asylum claims, and they're asylum claims for the same reason a political dissident case coming out of Zimbabwe is a viable asylum claim, and that's that the individual meets the definition that Ashley reviewed at the outset of this presentation. And they are refugees. They should win asylum because they have met all of the elements in the asylum definition. And so I think it's an important advocacy point for those of us who are representing these clients to reiterate that point. And I think we do ourselves a little bit of a disservice when we talk about how we're expanding asylum law or we're adjusting the definition to recognize these claims, because these are claims that from the outset cleanly fit into our existing asylum and refugee definitions and should be recognized as such. So we're seeing a lot of new judges take the bench at the immigration court level and a lot of turnover at the asylum offices. So we'll be seeing new adjudicators. And so it's worth being ready to educate them, if need be, about the fact that these are claims the same way any other of the more textbook or classic asylum claims are asylum claims. So let's go on to the next slide and talk about some of the common types of claims that are related to gang or cartel connection or involvement. And I say this with a very big caveat that this is not to the exclusion of a gender-based claim. And certainly when you're approaching these cases, it's extremely important to vet for gender-based claims that might arise among a claim that initially presents itself as, a forced recruitment claim or an extortion claim. There's oftentimes a gender component. And so it is definitely when you're speaking with your clients and drafting their affidavits and talking to their family members and gathering evidence, don't neglect the lines of questioning that would reveal to you if there was also a family violence or domestic violence or some other gender component in these claims. I feel like very frequently claims that are we initially view as, this is a gang claim or this is a forced recruitment claim, have a gender component component that emerges that becomes very important to include. And I would particularly say, when we're working with unaccompanied immigrant children at the asylum offices, I think they tend to be more comfortable recognizing family violence as persecution for asylum purposes, where they tend to be a little bit more skittish about forced recruitment or gang claims. So certainly make sure that you're exhausting all of those areas. But the type of claims that we typically see are the recruitment claims. So people who have been recruited or have been approached by the gangs or the cartels, if it's a Mexican case, or cartels that are present in other parts of the region. That's really common. And I think those are viable claims. We've won those cases before immigration judges. We've had them explicitly recognize that forced recruitment can form the basis of an asylum claim. At the same time, I say that, I think there's also a recognition that these claims can feel a little bit more legally tricky. Whether or not that's warranted or not, remains, I think, an active question. But at least in the Seventh Circuit, there's been some mention from judges in other decisions that they're not entirely sure that just these straight up recruitment claims are viable. But we believe they are, and at least at the IJ level, judges have recognized that refusing gang recruitment efforts can constitute can support an asylum claim. So keep an eye out for those claims, but then also, certainly if you're raising a recruitment-based claim, also consider other possible particular social groups or grounds for asylum that might be relevant. Extortion-based claims, so people who have run businesses or people that have lived in communities where there's a war tax or a vacuna or some expected payment from the gang or cartel in order to not be harmed. That's another common line of cases that we see pretty regularly. Witness-based claims, and here there's a spectrum of claims. I think there's decent recognition that people who have been active witnesses and have reported crimes and have appeared before tribunals or gone and viewed photo arrays, that's oftentimes an immutable characteristic or a characteristic for which someone should be recognized as potentially eligible for asylum. I would push us to broaden that spectrum and recognize, individuals who witnessed crimes by the gangs, but then maybe were never able to report them for whatever reasons. That still might be a reason why the gang is targeting them and why they might face persecution. And so we don't want to hold our witness-based claims to such a high burden and suggest that there has to have been, a police investigation and a prosecution, and the individual has to show that they've, been involved as a witness every step of the way. I think there is potentially, a less involved type of witness-based claim that could be viable. So keep an eye out for that. And former member affiliation. This is an area that's a little more comfortable legally, at least in the Seventh Circuit. We have a line of cases recognizing that former gang membership or former membership in a group may be recognized for asylum purposes. So there I'm talking about Benitez Ramos and Gatimi. And as we're throwing out names of cases, know that our presentation doesn't have a lot of the citations embedded in it, but we do have information about how to look at our webpage at immigrantjustice.org, where we have a brief bank and a real wealth of information available to you, and a lot of the cases that we're referencing are mentioned there. So please feel free to access that information along with the particular social group practice advisory that Ashley mentioned before. Imputed affiliation claims are another area that we're frequently seeing. So these may be people from the region who police may believe are a part of a gang because of their age, because of the way they dress, because of the neighborhood that they're from, and they may be targeted for persecution by government officials because they're believed to be gang members. Or they may be targeted by one gang because they're from a neighborhood that's controlled by a separate gang. Or they may be targeted because even though they never actually became a member of the gang, they were connected enough or had enough contact that when they refused to continue that involvement, the gang itself treated them as though they were a former member. So, there it's kind of halfway between the former member gang arguments and the imputed affiliation gangs. But certainly, look carefully at the facts of each case before you and be sure to carefully craft your particular social group to reflect the reasons why the persecutor is targeting your client. So with that, we can move on to the next slide, which addresses the types of persecution that that we see in these cases. And again, going back to all of the elements of asylum, usually we start our arguments with what was the persecution here? So what happened in the past, or what is the persecution that our client is fearing in the future? And we need to identify what that persecution is, and we need to identify harm that rises to the level of persecution. So in the gang recruitment claims, the recruitment itself, the initial approach by the gang of the individual to try and force him or her to join the gang or join the cartel, that might be persecution. What we want to be really careful about there is avoiding making some sort of circular argument where we argue that our client is, they're persecuted because they were someone who was recruited by the gang. So if we're arguing that recruitment was the persecution, and we're saying that the particular social group are, potential gang recruits, that's a really circular argument. There you're saying that the client was persecuted because they're persecuted. And so you need to be conceptually careful when you're making these arguments so that you're separating the elements. So maybe you're arguing that initial approach by the gang is persecution, and it was persecution because your client was, a young man from a certain neighborhood, and the gang targeted him to become a part of the gang for that reason. Now there you want to be a little bit careful again, because we've seen the Board of Immigration Appeals do some legal gymnastics to try and preclude those types of claims, and that's where they have these arguments about particularity, which are not particularly relevant in the Seventh Circuit and will hopefully be rolled back in other circuits. But we want to use a little bit of caution raising those sorts of arguments. I think more commonly we see persecution in the form of punishment for refusing that initial recruitment effort. So somebody who the gang approaches and the individual refuses to join the gang, and then subsequently the gang targets them. So now they've become a gang resistor. In making that initial refusal, they've placed themselves in the category of individuals who have refused gang involvement. And so that subsequent persecution, the targeting by the gang waiting for them outside school, or sending them notes that arrive at their house in the middle of the night and say, you've had 3 opportunities to join the gang and you've refused us every time. You have to join by Friday or there will be repercussions. Those are the sorts of persecution, those threats, that targeting, sometimes the beating, the targeting of family members, all of those things that follow the refusal to join the gang may rise to the level of persecution. And then you have other types of persecution that may be less traditional, like if you're unable to leave your house, if you're unable to go to school, if you're unable to conduct your work, or do the sorts of things that one should be able to do in the course of normal life. And here, arguing that those things rise to the level of persecution may be a little bit more challenging, and you want to make sure you have record evidence to include that. But here again, as Ashley said, we want to look to other sorts of cases. So we've seen in the Seventh Circuit, for example, a case dealing with the Hay Hazai, or children in China who, because they were not the first child, they were a second child born to a family, they weren't allowed to go to school, they weren't allowed to access government benefits. And the Seventh Circuit has recognized, and that case is called Shi Chen, and that case the government has recognized these things might rise to the level of persecution. And so if someone is so paralyzed in their day-to-day life by the way the gang or the cartel is targeting them, that might be persecution, and that's certainly worth exploring and raising. When we look at extortion as a form of persecution, we really have to make the record. So we can argue that financial harm, so the extortion itself is persecution, and Oliva Rivas v. Lynch out of the Fourth Circuit is a case that recognizes that the actual extortion can be persecution. And so look at the language in that case, because it gives us a really strong argument to show that that extortion itself, extortion alone is persecution, but also targeting or punishment for refusing to pay the extortion fees can also be persecution. So we just litigated a case in the immigration court this week where a family was held hostage and experienced sexual violence, and the family was beaten and threatened and stalked, and all sorts of things happened after they refused to pay the extortion fees imposed by the gangs. And so make sure you're exploring those avenues to identify all of the persecution that your client may have experienced. Interference with gang activity and flouting the norms is another area worth exploring. So we've seen cases where a parent has refused to allow their child, or they've intervened on behalf of their child to try and avoid having that child be recruited into the gang, and the gang has punished someone for that reason. So those sorts of, and that would be more a reason for the persecution, but if there's targeting that ensues because of that, look for those forms of persecution that may be connected to that. Generally, we want to avoid the term harassment overall. Harassment, almost by definition, isn't persecution, right? It's something less than harm that's going to rise to the level of persecution. And maybe you can make the argument that there's so much harassment that it should be recognized as persecution. But I just think as a term, it signals to adjudicators that this is less serious harm. And so oftentimes when we're translating from Spanish to English, our clients will talk about the way they were harmed in a way that translates to harassment. But generally, we want to steer clear of that word. So instead of saying the gang harassed me every day on the way to school, I would say the gang targeted me, or even the gang bothered me, even though bothered is maybe a little less strong. But I think the term harassment itself is a loaded word that judges and other adjudicators are pretty quick to seize on as something less than persecution. So let's steer clear of that terminology. And we can go on to the next slide, where we're talking about the particular social group tips. So again, we're a broken record on this, but you have to separate particular social group from Nexus. So the characteristic, the thing that places your client in their particular social group is different from the harm that they experience, the harm that ensues once they have placed themselves in the particular social group. So one way to look at it is to ask, what caused the persecutor to harm my client? And again, your client doesn't have to know the mind of the persecutor. And there's plenty of case law, particularly in the Seventh Circuit, that talks about a client doesn't have to know the mind of the persecutor. But what triggered the persecution? What caused it to begin? And start to parse those facts to determine what the particular social group, what the protected characteristic should be. And again, consider the initial reason versus the subsequent reason. So you may have to talk to a judge and say, and I've said this in my briefing, like, yes, this awful thing happened the first time the gang approached a client, and that was probably persecution. But that wasn't yet persecution on account of membership in the particular social group. That persecution, the persecution that makes my client eligible for asylum, happened after my client was identified by the gang and became somebody that the gang was targeting because of his or her refusal to do whatever it is the gang wanted them to do. And look again to other case law. And again, this is all a part of showing our adjudicators that these are cases that fall comfortably within existing case law that recognizes eligibility for asylum. So if we look to female genital mutilation cases, if you look to matter of Kasinga from the Board of Immigration Appeals, which says, young women from a particular tribe who refuse to submit to the practice of FGM should be recognized as a particular social group. Well, conceptually, that's not different from young men in El Salvador who refuse to submit and become members of Mara Salvatrucha. So make those parallels, show your adjudicators how this really is the same type of legal reasoning that applies in those other cases. So resistance to FGM, resistance to forced marriage, resistance to the FARC, so those are the Colombian guerrilla cases. There are a number of those in the Seventh Circuit. Escobar is a really good one that talks about Somebody who was a former truck driver who refused to do the bidding of the farm. Well, that's very similar to someone who refuses to do the bidding of the gangs. And so draw those parallels. So show the judge, give the judge or your adjudicator the tools that they need to be able to grant the case. And then we want to avoid some of the characteristics the same way we want to avoid language like harassment in our affidavits, in our briefing, in our testimony. We want to kind of steer clear of the types of characteristics that have been less accepted by courts. So somebody who's wealthy or Americanized or an informant, those are characteristics that courts have generally found are a little bit more squishy and not necessarily as immutable or recognizable for purposes of asylum. So from there, let's go on and talk a little bit more in the next slide about Nexus. And here you want to make sure, we've seen judges, as Ashley said, get a little bit tripped up on Nexus. And so, take special care in your case presentation to address Nexus on its own, separate and apart from particular social groups. So in your brief, have a section that addresses that. And when your client is testifying, make sure that you're making very clear that that you're identifying the reasons for the harm. And don't underestimate your client's ability to understand the concept. It's really useful for your clients to understand that what they need to do is show the judge that the reason they were being harmed was A, B, and C. And clients, even younger clients, even clients that haven't had access to education, can understand that we need to show the judge the thing about you that makes the gang come after you. What is it that makes you different from other people in your community who didn't experience that same kind of harm or didn't experience the same level of harm? We need to show the judge the thing about you that makes you a target for persecution. And what are the things that the gang did or the cartel did that made it clear that they were coming after you for that reason? So if your client was a witness and they got phone calls from the gang saying, you better rescind your report, or you better not show up to testify, or you better not speak about what you saw, or else, these terrible things are going to happen to you. Make sure that you're making that connection and establishing that the reasons for the harm were because of this protected characteristic. So again, just don't underestimate the necessity of highlighting those things, even if it feels pretty elementary and obvious. I think making that a big part of your case presentation is important. And don't let letters of support or corroboration undercut your case. So sometimes we'll ask our clients, gather letters of support from your community, or letters that corroborate your case, letters that talk about what happened to you, and you get letters back from the community that say, oh, it's so dangerous here, everybody's in danger, nobody can leave their house. What that tells the judge or adjudicator is that there's generalized violence. And so unless you're getting letters of corroboration from community members that actually help your case, be very careful about what you submit. I think we're oftentimes so tempted to submit any corroboration that we get that we can really undermine our own cases by submitting things that actually don't further the legal arguments in our case. So be sure to provide your witnesses with the information that you need them to address. So, that might mean that you're sending them a list of questions. Like, if you're willing to write a letter on behalf of my client, these are the things I would like you to address. How long have you known him? What do you know about what happened to him? What happened to him? How is that different from what happens to other people? And I think, the gold standard is if you're able to, hop on WhatsApp or get on Skype or whatever and interview potential witnesses directly so that you can help them articulate the things that you need them to say to support Nexus. So again, this just goes back to recognizing that there aren't shortcuts in preparing asylum cases, and you really have to do that legwork to make sure that you're gathering the necessary evidence to support every element of your case. So with that, let's move on to our next slide. Which is, again, just more about corroboration and making sure that you're gathering that evidence. Statements made by the persecutor, that can be really critical to show the reason why the persecution is happening. Like, you refused to pay the extortion fees, and so now here we are at your doorstep. And then also looking at country conditions evidence in context, and you know, make sure that your record, that your country condition information supports the claims that you're making. And not only that it does that, but that you know how it does that, and you include that in your briefing and in your closing arguments and in any kind of oral engagement that you might have with your adjudicator about the case. It's not enough to just recycle a country conditions packet that maybe you used in another case. You need to pull out specifically what is the information, what is the, you know, what are experts on El Salvador saying about what happens to kids who refuse to join the gang, and how can we pull out those key components of our country condition documents and be ready to talk about that. You have to be conversant in your record when you get to court, and that means sitting down and reading through that, you know, all of those pages of country condition articles every single time before you go into court, so that you're ready to have that conversation. Because almost without exception, the trial attorneys, you know, in their arguments, they'll say, we don't doubt that there are awful things happening in Honduras, but they're happening to everybody, and this is generalized violence, and, you know, we can't just grant asylum to everybody. We can't open the floodgates. This is, you know, tragic, bad stuff happening. But and you need to be able to push back and say, like, well, you know, it is true that there is unrest in these countries, and there is a lot of gang violence. In my client's case in particular, what makes him or her different from the average person, and what makes this something other than mere generalized violence, is A, B, and C, and be ready to talk the adjudicator through those things. So we can go on to the next slide, which shifts things back to Ashley to talk about gender-based claims.
Great. So, you know, we've broken this presentation really up into these two types of claims. Like Lisa said, these are the most common types of claims we see. Of course, there are other types of claims that come from these countries, but since these are most common, we wanted to focus here. And so we're going to talk about, you know, 4 common types of gender-based claims that we see, again, with a caveat, like Lisa said, that there's often an overlap between the gang and gender claims. You know, young women or women and girls who are being targeted by gangs are often targeted in a very gender-specific way. Conversely, if a woman is in a relationship with someone who is a gang member, that the fact that he is a gang member are going to have particular implications for her as well. We often see other types of overlap between other claims too, arising out of Central America and Mexico. So, for example, someone who has a claim based on their sexual orientation or gender identity may have aspects of their claim that do float into this sort of gender violence type area as well. And of course, are also going to have implications with the gangs and that's, or the cartel in that particular situation. But again, the most common types of claims that we're seeing that are gender-based coming from Central America and Mexico are, so first, you know, a standard domestic violence claim. So this could be somebody who is married to an abuser, someone who's in a relationship that's not a marital relationship to an abuser. You know, it could be something long-term, it could be something short-term, but it's within that sort of domestic type relationship, whether or not they're actually living together. And we'll talk a little bit about how those social groups are formulated in a second. And then there's a forced girlfriend type claim, and we see different variations of this as well. So this could be something more along the lines of a domestic violence, a standard domestic violence claim where, you know, a woman is in a relationship with somebody and they're not married, or it's not, you know, that sort of long-term common law marriage, but the boyfriend won't let her leave the relationship. But what we often see is a woman who wouldn't really perceive herself to be in a relationship with somebody, but the perpetrator of the abuse, the persecutor, is treating her as if they are in a relationship and is forcing her to be in that relationship. And we often see that in the gang context. So a gang member will focus on a particular girl or woman and will say, you know, you need to be my girlfriend, and will start to threaten her, and those threats will escalate, and he may threaten her family, and there's, you know, typically a general understanding that to become the girlfriend of a gang member in this context will typically also involve other forms of gender violence related to the gang as a whole. So we see that quite a bit. And we'll see it often at various stages too. So we see clients who, you know, the family learns that, you know, a teenage girl was all of a sudden being targeted by a gang member, and so the family gets her out of the country really quickly because they know what will happen if she stays. So nothing serious has happened to her yet because her family was able to get her out before things got worse. And then we'll see things where it's much more escalated, where, maybe the young woman was being held at knife point or gunpoint and being told by the gang member that, you need to be my girlfriend or I'm going to kill you. So there's many different variations on this type of claim, but I think particularly with some of the good country condition evidence you can find, all of those claims along that spectrum can be viable. And then we see family violence claims. And so this isn't necessarily always gender specific, although it can often have a gender specific component. Like Lisa mentioned before, in the Chicago Asylum office here, and I would say the Chicago Immigration Court generally as well, child abuse-based claims are generally very viable. And so, we'll often see family violence claims related to that. And maybe there's other claims as well, but that family violence claim is often what can win the day with our adjudicators here. But we'll see that in other ways as well. So we'll see, sexual violence and gender violence being inflicted by family members. So with, children and young adults, we'll often see this in the context of maybe the parents left the country to come to the United States. They leave their daughter in the custody of an aunt and uncle, and the uncle begins to sexually abuse their daughter. So those types of claims as well. And finally, community violence. And we'll talk a little bit more about this, but the way we look at these claims is gender violence in the context of these particular countries is not random and not just an isolated criminal incident. And so even if the gender violence is being inflicted by somebody that was not in a relationship with the individual, often when you look at country conditions, you can really connect it to protected characteristics that the client has and therefore really establish a very strong asylum claim in many cases. So we're going to break this down into the same way we did the past section, going through some of the elements. So for persecution, I think the one thing that we always try to emphasize in these cases is many of our clients may not necessarily initially identify gender violence as the reason they're seeking asylum, because maybe they fled because they were being extorted and they couldn't pay the fee anymore and they thought they had to leave, or they fled because maybe a gang was trying to recruit them, or maybe another family member was in danger and they all came together. But unfortunately, more often than not, when we start to talk to our clients or female clients and explore their family history and their background a bit more, a significant portion of the time, some form of gender violence came up. Maybe it was molestation incidents when they were younger. Maybe it was a rape as a teenager. Maybe it was an incident of domestic violence with a prior partner. So it's really critical to explore those. Obviously, you need to often develop a lot of rapport with the clients before you can do so. And, make sure that in your intake interviews and your affidavit preparation interviews with your clients, you're giving them space to talk about this other information and not sort of leading them in a direction that you think is what their claim needs to be focused on. So as I said, we have another webinar that talks about working with children, working with domestic violence survivors. I encourage you to take a look at that because getting this information out of clients often takes a significant amount of time. We've had clients where we've had meetings for months and months and months, and it won't be until right before the asylum interview that a client will finally acknowledge that she said she'd only been threatened by the gang members in the past, but actually during one incident, they did rape her, and she hadn't told anybody before. So it's really important to make sure you create safe spaces for clients to disclose this information without other family members present, and you give them the space and the opportunity to talk about information that may not be directly related to the reason they initially identified as the basis for their claim. So when you're talking to clients about gender violence, you really want to try to break it down into the various forms of harm that this can take. So first is the idea of threats. Along the lines of the harassment comment Lisa made earlier, we want to avoid the terminology sexual harassment. So if your client regularly walks down the street and gang members make sexually explicit comments to her, we want to frame those as threats because obviously they're meant to intimidate and control her. So, frame those as threats, not as sexual harassment. And threats can rise to the level of past persecution if they're imminent or credible or menacing. And so you can argue that when gang members that are well known to be very menacing and to follow up on their threats and to carry weapons, threats in that context can constitute persecution. You want to look at, along the same lines, emotional and verbal abuse. So particularly in the context of a relationship, if the perpetrator of the abuse of the persecution is constantly making comments to your client that may not necessarily be threatening but are having a significant impact on her emotional well-being, you're going to want to frame those as past persecution as well. And often what you're going to need to do is to get affidavits from mental health professionals and things like that, as well as the statements from your client herself in her affidavit to explain how did she feel when these things were said to her. How did she feel if other people heard the abuser saying these things to her? Does she think about those things now? Does she have nightmares about her abuser saying these things to her and, physically abusing her, and really to establish how that rises to the level of persecution. The other thing to keep in mind, particularly for non-physical harm, is the age at which it occurred. The Asylum Office and many other courts of appeals have it well established that harm to the level of for a child does not have to be as high as it must be for an adult in order to constitute persecution. So it can be less severe for a child than an adult and still constitute persecution, which is really critical to emphasize when you're talking about this non-physical type of harm. In gender-based violence, we also often see harm to family members as a means of punishing or controlling the asylum seeker, right? So in a standard domestic violence situation, the abusive spouse may use the children and harm the children as a means of controlling the partner, right? And there's a lot of case law that talks about that as well. In the Seventh Circuit, there's a great case called NLA v. Holder, which talks about how harm to a family member, particularly when it's harm to a family member that's intended to harm the applicant, can constitute persecution. And then, of course, we have your standard forms of persecution, sexual assault, beatings, and rape, and things like that. But what's really critical to keep in mind here as well is if your client has any kind of domestic violence or forced relationship claim, you really want to spend the time to walk through with your client various things that he made her do that she did not want to do. Because very frequently what we will find is that a client will not necessarily recognize or acknowledge to herself that when she was forced to have sex with her partner, it was rape. Because she may say, well, he didn't force me, I just knew that I had to do it because I didn't want him to be mad. I didn't want him to get mad at the children. I didn't want him to get mad at me. And, really walk through, whether something was consensual. For girls, we often want to look at what was the age of the perpetrator. So, sometimes we'll have 12 or 13-year-old girls who would get in a relationship with maybe a 25-year-old man, and they don't necessarily see what happened as rape because they thought they were sort of in a quasi-relationship with the individual, and sort of talking through, what's the age of consent, what's acceptable in the country versus the age of consent, and see if you can make an argument regarding statutory rape and things like that. So this is something that is important to take the time to walk through. So then moving on to particular social group, again, we keep emphasizing separating the social group from the nexus. Do not define your social group by the harm suffered. So in a domestic violence-based claim, you don't want to define your social group as Salvadoran women who have suffered domestic violence, right? Because that's a circular definition. Your client was not subjected to domestic violence because she suffered domestic violence, right? So you want to make sure you're separating the social group from the nexus and defining the social group by the reasons she was targeted, not the form of harm itself. And in these types of cases, we generally find it best to try to track the language of established social groups. So, we have the board's case in matter of ARCG, where the board recognized the social group of Guatemalan women in marital relationships they are unable to leave. So, use that established social group and make your client's social group track that type of language. So maybe your client wasn't in a marital relationship, maybe it was a domestic relationship or it's an intimate relationship. Describe it how you need to describe it to fit your client's facts, but also to establish that it was immutable. Because in ARCG, the board only used marriage as evidence of why the relationship was immutable. Marriage itself was not a requirement to establish the particular social group. And there have been a number of unpublished board decisions since that time in which the board has said, no, marriage is not a requirement to be part of this social group. And you can see some of those unpublished decisions on NIJC's website. At the same time, we do want to continue pushing this idea that gender should be a particular social group on its own. In many of these cases, it's ultimately the client's gender and perhaps the country of origin that really gave rise to the harm, that really were the cause of the persecution. We know that adjudicators are very uncomfortable with a gender-only social group because of these sort of underlying floodgates concerns and other concerns that really have been found to have no basis in reality. But, we know they're nervous about it. We don't want to present that as the only group, but we want to continue emphasizing it as a possibility. So what we'll often do in our cases is we'll say, my client belongs to the group of Salvadoran women or more narrowly, Salvadoran women in intimate relationships they are unable to leave. So provide those two options. And again, look at ways you can use that social group for the non-explicit domestic violence cases. So if you have a client who was being targeted by a gang member who wanted her to be his girlfriend, and she does not consider herself to have been his girlfriend, but he kept saying things to her like, you can never leave me, you belong to me, you can't be with another man, you're mine. You want to look at those words, those phrases, and use that as evidence to show that in the view of the persecutor, this was an immutable relationship. And then you use country condition evidence to establish that this is consistent generally with the way gang members are treating women, and really draw that bigger picture of what's going on. The other type of social group that will often present in these types of cases, especially for younger women, would be a lack of parental or familial protection. So for unaccompanied children in the Chicago Asylum Office, we've often found that arguing domestic violence or family violence claims based on social groups around the idea of being a child who lacks parental or familial protection is typically very viable. And there's good country condition evidence to establish that in families where the parents have migrated to the United States and have left the children with other relatives, those children are particularly vulnerable for child abuse and sexual abuse and other harms. And so you can use that evidence to help establish that your client was being targeted because he or she lacked that familial protection. Sometimes your client may say things like, I was living with my aunt and uncle, and I lived with my cousins who were their children, and my aunt would always beat me, but she would never beat her children, right? And so you can tie that to the idea of, she lacked familial protection, whereas her cousins did not, and that was the reason that she was being targeted. So then moving on to Nexus, what's really critical in gender-based claims is to establish that the persecution was not random, was not a personal dispute. So despite the fact that it's becoming much more understood and accepted that rape and sexual assault are not acts of, sexual desire or because someone is attracted to someone, they're acts of control, we still see comments from adjudicators that the gang member was only interested in her because he was attracted to her, or he only, was threatening her and stalking her because, he loved her. And statements like that are just completely out of sync with what we understand and what we know about domestic violence and gender violence and country conditions and all that sort of thing. So it's critical to go into a case being ready to respond to those comments. In addition, you really want to talk about the underlying source of gender violence. So what we, will frequently argue is that in some of these countries where you have such high levels of femicide and gender violence and such high levels of impunity for gender violence and femicide, that rape is not a random criminal incident, or sexual assault is not an isolated incident of personal dispute. It's a result of this understanding in the country that it is okay for men to treat women this way, and the police understand that it's okay for men to treat women this way, and it's part of this bigger sociological picture of the country that this is happening. So, I think it's very viable to argue that a woman who was raped and was not able to report it to the police in her country, even if she doesn't know her rapist and doesn't know if the rapist was a gang member, can potentially still have a viable gender-based claim depending on the country of origin. And if you have a country like El Salvador with really high gender violence rates, or Mexico where there's very high rates of gender violence and femicide and impunity for this types of harm, you can make that argument. Corroboration, though, is really key to try to establish that. And so in gender-based claims, we really tried to break the corroboration down into three parts. So first you have the direct evidence, which is your client's statements mainly, and maybe statements from others that are talking about what did the persecutor say to your client? What did he say that shows that he thought they were in a relationship that cannot be left, that cannot be changed because she's always going to belong to him? So look at that direct evidence. But then we look to the circumstantial evidence as well. And we like to make two very specific arguments here. One is that the type of harm itself in a gender-based claim is evidence of the reason for the harm. And this comes from Matter of Kasinga, which is a case involving female genital mutilation, in which the Board of Immigration Appeals basically said, look, the act of SGM itself has a particular gender focus. It's intended to control women and to change a particular part of them. And therefore, we don't have to look behind the FGM to find out why it occurred. It's inherent in the act itself. And that is the same thing you can argue in gender-based claims. So, there are some good sites in Court of Appeals case law that talk about, rape is an act of power and control, that some of these types of harm are very gender-specific types of harm. And so the fact that that very gender-specific type of harm was being inflicted on the asylum applicant is evidence that it was being inflicted for a gender-specific reason. And then finally, looking at the country condition evidence and really using that as strong corroboration for the social group. And there's this great language in this case called Sarhan in the Seventh Circuit involving a woman who was fleeing honor killing in Jordan, in which the court says, look, this is not a personal dispute between the perpetrator and the woman here. He is trying to kill her because society has deemed that this is permissible and the government has withdrawn its protection from the victims. So you can use that and use other similar language in other circuits to argue that when you have high levels of gender violence and complete government inaction or impunity for that violence, that demonstrates that harm is on account of a particular social group, that the man was abusing her because society had deemed it was okay. The gang member was forcing this girl into a relationship because society has deemed that it's okay. And so really trying to use the country condition evidence to prove that that social group is connected to the reason for the harm. So we're going to very quickly just touch on relocation and governmental control, which are the other two elements for asylum. And then we will connect you with some other resources for your cases, and we will be all done.
All right, so thanks. So let's flip to the next slide on internal relocation. Because I think this is particularly in Central American cases, it's easy to neglect this because for those of us that have been working on Central American cases, it's very clear these are tiny countries. Persecutors, abusers can track down our clients anywhere. We're all aware that the gangs are networked and so forth. But again, because we have so many new adjudicators, it's not safe to assume that the judge understands that. So go ahead and make sure that you're making that argument, that you're supporting it with country condition information. If your client did at one point go and live somewhere else, or if they have other family members in the country that are still there and aren't experiencing the same level of harm, be able to explain, be ready to explain why your client is different and why your client couldn't similarly live in another part of the country without harm. So be ready to make those arguments. Be tuned in during your hearing, whether it's an asylum interview or your hearing before the immigration judge. And in your closing argument, if the judge seems to be concerned about that, or if the trial attorney has you think had an impact or raised that, be ready to talk about why internal relocation isn't viable because of what we know about the country conditions. And I usually say, like Guatemala is the size of, New Jersey or whatever a comparable state is, to talk about the size of the country and then, point to information about the gangs being networked. When we're talking about Mexico, of course, you have, a very different dynamic where you've got a huge country where why couldn't your client who lives in Guerrero go live down in Chiapas and be safe? And so there you need to be able to talk about, if we're afraid of the cartels, like does the cartel have reach beyond the state where the client is from? And there are a lot of cartel areas of control maps that are available that you can just Google and find to talk about cartel presence in different parts of the country. We have in a case called RRD v. Holder, we had a very strong amicus affidavit where we had an expert talk about how the cartels, once they place you on a hit list, that hit list goes out to mercenaries all over the country, and there's no way to rescind that list. Once your client is on that list, then he or she, is at risk of being targeted not only by the cartel, but by people who are trying to gain favor with the cartel all across the country. So be ready to make those arguments. And beyond that, it's really important to recognize that internal relocation has to be reasonable. So not only possible, but it has to be reasonable. So if your client is a young woman, can she reasonably go and live somewhere else where she doesn't have a network of support, where maybe she can't access employment, or it would be dangerous for other reasons for her to live in that place? Be ready to make that argument on the reasonableness, because I think that's another argument that adjudicators tend to overlook when they're conducting this analysis. And additionally, Ashley mentioned NLA v. Holder. One of the other strong holdings in that case is that people aren't required to live in hiding. So if your client could relocate and change their name and not go out or change their schools or essentially live in some level of hiding. That's not what our laws require in order for someone to win asylum. And so be ready to make those arguments and additionally consider other serious harm arguments. So if your client could relocate somewhere else but might be harmed for other reasons, be ready to make those arguments. Again, there might be gender elements there, and that certainly connects very directly to the reasonableness question about whether your client can safely live somewhere else in the country. So don't neglect relocation. Make sure you're ready to talk about that and you address it in your briefing and in your country conditions documents, and have your client ready to talk about it. Assume it's going to come up on cross-examination, even if you don't anticipate bringing it up on direct, and prepare your clients. Prepare so they're ready to talk about why that wouldn't be a viable option for them. And then finally, we wanted to talk about government unwilling or unable to control. So, in many of the arguments, where you have evidence of corrupt governments, you're probably going to argue both that the government is, outgunned or outmanned by the gangs and the cartels, but also that the governments might be corrupt or even complicit in the type of persecution that's happening. We talk about cases where clients understand that, I just reviewed a case where a client didn't go into a witness protection program because she knew or he knew that corrupt government officials would turn over his location or her location to the persecutor. So think about making those arguments, consider arguing both of those things. The New York Times this morning had another article about levels of corruption in Mexico, so make sure that you're including recent and timely information on those elements. And look to whether there are laws when we're talking about gender-based claims. Maybe there are laws about domestic violence, or, in Sarhan, there were laws against honor killings, but they weren't being enforced. And so if that's the case, then you have a government that's unwilling to control the persecutor, and maybe is in certain ways the persecutor itself. And then be ready to make the futility arguments. A court should not require that our client, at great risk to herself, go and try to report a crime, knowing that her abuser is immediately going to be informed that she's made that report, or knowing that the gangs are going to know immediately if they go and report a crime. And so it's not evidence that, your client has failed to demonstrate government inability or unwillingness to protect. If country conditions support the notion that taking those steps, trying to engage government support, would have led to other harm or would have been futile. So, be aware of these additional components in addition to all of the elements of asylum as you're building your case. And I think you'll go far in protecting the rights of your clients and hopefully enabling him or her to secure protection. So we can go on to the next slide. We just had a few other links on our next slide that talk about some of our resources. Again, this presentation hasn't been super heavy on citations and references to cases and so forth, precisely because we have all of that information available on our webpage. So please access what we have available to you as you're preparing your cases, and certainly feel free to reach out to us as you're putting together your presentations of your cases. Our next slide has our contact information, and I will kick it back to Ashley for the final word, but we certainly appreciate your involvement and the advocacy work that everyone out there is doing on behalf of asylum seekers, and we're very proud to be a part of that and hopefully support your important work in this area.
Right, so thanks everybody for participating today. We will have the recorded webinar up on our website within the next week or so, along with the PowerPoint itself, so you can access those links on the slide. Our website at immigrantjustice.org has an entire section under attorney resources devoted to asylum resources, and in that section there's specific information regarding particular social group and gender-based cases, in addition to a pretty voluminous archive of country condition resources for these claims as well. There are no questions, so I think we are done. Thank you again for participating.